Hi, I'm James Minick, and today we're going to talk about the entrapment defense in the context of a DWI case. I often have clients that ask about whether or not the entrapment defense would be something that we could argue. And although I've never had the opportunity to argue that in a case that I've been involved in, during my research on these affirmative defenses, did find a case from my home county of Buncombe where the entrapment defense was found by the court to be an appropriate defense in the particular circumstances. To prove a entrapment defense, the defendant has to prove essentially two things. First, that there was acts of persuasion, trickery, or fraud that were carried out by law enforcement or their agents to induce a defendant to commit a crime, in this case driving while impaired, and the criminal design originated in the minds of the government officials rather than with the innocent defendant, such that the crime is the product and creativity of law enforcement authorities. And that is, I think, the big question is, where did the intent to commit the crime originate? In a case, State versus Redmond, the defendant had gone out with a friend, consumed several alcoholic beverages, went to his girlfriend's apartment where his car was parked, did not have access to the apartment itself, was dropped off by his friend, basically got into his vehicle and was waiting effectively for his girlfriend to return home so that he could go inside with his girlfriend, and he was planning on spending the night there. Law enforcement officer came up, talked to him for several minutes, basically told him that he could not stay in the parking lot, that he had to leave. During his conversation, it smelled alcohol, so the officer knew that or suspected that he had been drinking, told him that he had to leave. Then officer left out of the parking lot and waited just outside the apartment complex. Several minutes later, defendant is driving down the road and is stopped by that same law enforcement officer. I think the two key facts in a DWI case that would be helpful to obtaining an instruction from the judge on entrapment would be that the officer told explicitly or implicitly the defendant to drive, and that the defendant did not plan on driving prior to being instructed by the law enforcement officer to do so. I think those would be the two key facts. The burden of proving the entrapment defense is on the defendant to prove that to the satisfaction of the jury. This is a defense which is required by the defendant is required to give notice to the state if it wants to use the entrapment defense upon request from the state under North Carolina General Statute 15A-905 C1. This is one of the defenses that is listed as being subject to discovery and notice. There is a standard pattern jury instruction about the defense of entrapment, and that is listed on our blog on the entrapment defense in the DWI context, and please go to that blog for more information on this topic. Thank you.